Good afternoon, everyone, and thank you for joining us for this interesting session that we are going to run for you guys on sort of the new landscape as it's unfolding before us. And frankly, you know, we've now almost gone a year. It's hard to admit that, I guess, but we have to accept it's been almost a year to the day that we all were hunkering down in place and making our plans and changing all of our policies and trying to figure out what the law in the future would hold. Anyone who's on this call hopefully is healthy and your families are doing well, and we're all doing what we can. Our goal here is to help provide a little bit of guidance on some of the emerging trends and the sort of upcoming dates to keep an eye on. As we transition back, all of the folks who were waiting to see will stop waiting to see. And when employers make decisions about what happens with people following this turbulent, hopefully unique period in our history, those employees and their counsel are going to be making decisions based on some of these legal changes and things that have been done by the government. So let's, without any further ado, we're going to take you through that. My colleague Ryan Conlin will, of course, be speaking on a number of these topics. I've got the conch first. If you have joined us before, you'll be aware that to ask a question, all you need to do is on the right-hand side of your screen, there's a little control panel. You can click the button to add a question, and we will be looking at those at the end of the session, and we'll get to as many as we can that are relevant to the whole group. If you have individual questions that are really just for you, probably better to follow up with us later on. We probably won't get to those questions during the session. If you cannot see the question box, then you probably have to click the orange arrow to expand the control panel, and then you can click the question button and send in your question. And again, we'll get to those we can. So without any further ado, let's get to the first topic here. If I can get my slide presentation to work. There we are. So infectious disease emergency leave, layoffs and terminations. So I have been keeping my ear to the ground and my crystal ball in full working order from the beginning of this thing, watching the government in many cases almost fumble around in the dark, trying to help employers, I think, and employees, but in many cases, given the unprecedented nature of this challenge, doing what you can isn't always going to be as easy to implement and often creates some confusion and delay going forward. One of the decisions that the government of Ontario made, unlike in some other jurisdictions where they simply sort of extended the time for temporary layoffs from what previously was a shorter period before it was deemed a termination to longer periods, in some cases up to 6 months or even longer, before those would be deemed terminations under their statutes. Here in Ontario, we went a different way. We created the Infectious Disease Emergency Leave. And as many of you, especially those who have joined us before, will know, the government has extended this program multiple times. So initially, they announced it when everyone in Ontario on temporary layoffs would have reached 13 weeks in 20 of a temporary layoff once COVID started in March. And so all of those folks would have been deemed terminated unless benefits have been provided throughout or other substantial payments. And so the government had to act quickly. And so they acted very quickly on the eve of those terminations to enact this regulation or to promulgate it, infectious disease emergency leave. And essentially what this does is convert the layoffs or reductions in hours that were implemented as a result of COVID, and that's important, it can't be some other factor or cause, those are now deemed to be actually not layoffs, not reductions that are constructive dismissals, for example, but instead infectious disease emergency leaves, which are a protected leave under the Employment Standards Act like any other, like the emergency leave we used to have, which has now been converted to sort of the personal leave and the bereavement leave and those things. Now this is a protected statutory leave and all the same rules apply. One key difference is that the benefits don't have to be continued unless you have a contractual obligation to do it. And it does not, and I think this is very important, and we've been saying this over and over again, but this is really the sort of what's been missing from a lot of employers' plans, is that these provisions do not expressly apply to common law. So as many of you know, there's the statute and the regulations, which provide sort of the minimum standards and protection. And then there's your contract and your common law judicial decisions. And those other things, that common law, those judicial decisions, those have held many times that a layoff being permitted up to a certain duration following certain prescriptions under the ESA is not the same thing as providing an employer the right to initiate a layoff in the first place. And so we're all hoping that the courts take a practical approach, see that the transition, which is a little bit different here because we're deeming people to be on a layoff, not a leave, rather, not a layoff, excuse me, that will be different than the provisions which simply say, here are the limits on a temporary layoff. So hopefully these layoffs will be deemed by the courts to actually be leaves under the Infectious Disease Emergency Leave, but we don't have those cases yet because we're still in the middle of the deemed leave period. Next, we have that the leave has gone over various iterations. They keep extending the deadline of that deeming provision, but as it stands, unless it gets extended again, July the 3rd will be the end of the deeming of a temporary layoff to actually be a leave. And so if you started a leave after March 1st and it was related a layoff, which became a leave as of March 1st due to COVID, it remains on, that employee remains on IDEL until July the 3rd. And so on July the 4th, that would be the first day of what would be a temporary layoff unless you take other steps. And so this is becoming increasingly challenging for our clients as I deal almost weekly with concerns or questions as some businesses are able to start transitioning back, bringing people back from layoff, recalling people from these leaves. And the problem is where you have a right to return to your position following a statutory leave, that creates this obligation on employers really at an unprecedented scale that we really have never seen before. These rights are individual employee rights. So when an employee is placed on a statutory leave and they are due to be recalled or returned to work, they have the right to their job if it still exists, or if it doesn't still exist, they have the right to be given an alternate position at the same essential compensation structure if their old job does not exist. And so the real problem here is that normally when you're considering these, the simplest example, the most common would be someone returning from a paternity leave or a maternity leave, right? So you're on this parental leave, you come back, there might have been 5 people in that department, they all had to cover, or maybe we had someone coming in on a temporary basis. And then when that person is done with their leave, it's fairly common, it's fairly simple. We're used to bringing people back and reintegrating them in that scenario. What we're not used to doing is having 30, 40, 100% of our workplace off on a leave and then having to bring them back following a pandemic as we transition back to reopening in whatever the new normal is going to be. And so I think the real challenge for employers here is, okay, our business has changed, our business needs have changed, the individual employees still have these rights to be reinstated, and if we don't reinstate them, either to their position or another position if it exists, and we say to them, we don't have a job for you, but we apparently have work for 3 of their coworkers, well, then we have some explaining to do. Now there's a question. And the Act says that it's the employer's duty, it's the employer's onus to show that the reasons why that individual did not get reinstated, either to their position or another, had nothing to do with the fact that they were on this leave. And so you have to show as an employer that clearly there were business reasons why that person, in this scenario where we have multiple employees and only some come back, there were clear bona fide business reasons why one set of people came back and this set of people were left off the recall list and ended up having their employment terminated. And that is going to create, I think, the greatest challenge in a statutory leave scenario that employers, that even the Ministry of Labor or the Labor Board have ever had to deal with. And these are going to be very fact-specific situations, and they're going to be evaluated on the basis of your workplace. And if an employee is unhappy that you didn't select them for recall, it's a free application to the Ministry of Labor. It takes about 10 minutes. They file a button, they file it, they click a button, and we've already been seeing within days of these applications going in for some employees who are complaining that other people are getting recalls and they're not. Within days, the ESA officer will contact you, will send you a demand for records, will advise you that this is a claim that you failed to recall and reinstate someone following a statutory leave, and that the employee is asserting reprisal. Reprisal is serious. If you get found to have committed a reprisal, they could get reinstatement, they could get back pay from the date that they don't get reinstated, and they could get general damages and compensatory damages. So this is serious, and you might multiply it by the number of employees you don't select to bring back to work. Now, earlier cases, the Labor Board has made it clear that the IDEL, or any other statutory leave rather, does not impinge on an employer's right to conduct their business in the normal course. And so that's where we go back to this situation where the employer will have to show that there were business reasons that were bona fide and that had nothing to do with the leave, and not to COVID. And so it's going to be a little bit of a balancing act to demonstrate that if you had to make business changes in this transition and that resulted in less work, and some employees came back and some didn't, or perhaps none came back in a particular area, that was not because they were off on this leave and you're failing to bring them back. And so I think that's something we all have to keep our eyes on. And so as we move in this transition, and again, as I said, we've been seeing a lot of our clients have already been starting to get these reprisal complaints through the Ministry of Labor. We've already been getting them. And so as we transition our way back, this is a real challenge. I think we all have to keep our eye on it. So how do we avoid some of these claims? Keep your employees updated. And I've been saying this from the beginning, but now, especially as we've been seeing these claims already, critical as you make your plans to transition back and recall people, you follow these recommendations, I think. Keep employees updated. People who are in the dark are more likely to file a claim. Lay people off on IDEL to the expiry of that. And if you're going to bring people back early, then make sure that you have kept your records of your reasons, and you can show with objective evidence, not just we like this person, they're more efficient, they're less efficient, okay? You can show with records and reasons why you selected one employee for recall over the other. Ask for severance volunteers. It is absolutely legal to say to an employee, you're off on a leave. We have every intention of honoring our obligation to recall you if you want to remain on that leave and await a possible recall, but we don't believe we're going to have your job or a similar job available come July. Or in the future. And it's up to you if you want to stay out there, we will respect that. But if you would like a severance package in exchange for a release and waiving your right to recall, then let's do that. And then get a lawyer to draft a letter to that effect and a release, get them signed off, give them a package, and then sidestep this landmine entirely. So now I'm going to turn the conch over to Ryan. If I can just bear with me for a second.
All right, and as Jeremy gets that organized, good afternoon, everyone. This topic is one that's is an interesting one. Obviously, it probably doesn't come as a surprise to you that the courts and certainly plaintiffs' lawyers are certainly going to be considering the impact of COVID-19 on what will be awarded for wrongful dismissal damages. Everyone in our firm, and certainly everyone on the management side end of the bar that we've spoken to, has certainly seen plaintiff lawyers suggesting that there should be a significant COVID bump for reasonable notice periods, ostensibly on the basis primarily that in some instances it's more difficult for an employee to find a new job if they're terminated during the global pandemic. Of course, it probably won't come as a surprise to you to know that the economic hardships associated with the pandemic for employers is not, at least to this point, been used to justify reducing notice periods in any way. So, Jeremy, it's not moving. Oh, there it goes. Okay, so what have the courts said? Thus far, it probably doesn't come as a surprise to you that the courts haven't said a whole lot thus far specifically related to COVID, as the volume of litigation in the civil courts is only just starting to pick up now, because basically almost all the trial courts and in-person appearances have been grounded to a halt. So what's mainly been proceeding in court is motions and discoveries and all other matters that are being conducted virtually. Can I get that slide to go back here? All right. So ultimately, we know from pre-COVID case law that there is that courts have said that when there is a downturn in the economy general or in a particular industry, that will cause someone to have a more difficult time finding a job, that is a factor that points to a higher notice period. So I don't think it's going to come as a surprise to any of you that this type of reasoning could be used by a court to increase what it is an employee might otherwise get. But certainly, I think what the devil in that is in the details as to how much is it going to increase it, and how much is the factor of the pandemic in a way, aside from the other usual factors that are important in terms of assessing reasonable notice, which in most cases has really been the nature of the position in length of service and the age of the employee. Sort of big three of the factors that came out of an old case called Bartle versus the Globe and Mail, which remains the sort of the seminal case on what is reasonable notice, where there isn't a contract that spells out what that notice is. In the next slide here, we have a decision from one of the first decisions on this issue, which is the Yee versus the Hudson's Bay Company case. And basically, that the court points out that if a termination did take place before COVID, remembering that employees have about 2 years to bring a lawsuit. But basically, if it's pre-COVID, the courts, they're going to take into account the circumstances that existed at the time of the termination. But ultimately, of course, it seems likely that the converse of this reasoning is that if someone is fired during the pandemic, there's going to be some suggestion that a higher notice period is in order. So moving on to the next slide. So what is really the takeaway? What is the bottom line that you should take from this? There's no question that if you terminate an employee in the middle of a pandemic and you are in an industry that is impacted by COVID-19, and that's of course is not true of all industries. If one's looking for a job in a long-term care home, I don't think one can say that COVID is a factor, as opposed to say the restaurant or the airline industry, which is something else altogether. And in both cases, has been virtually ravaged by the impact of the pandemic. But the thing is, what I want to be clear about is, certainly from our perspective, some plaintiffs' lawyers have taken the view that the pandemic basically means that the notice period doubles, or that there's that this is a panacea for employees, that we're entering a whole new, brave new world. And we don't have any significant amounts of case law on that issue. But my perspective is that's not the case. The reality is that, though it's hard to say, and as courts are very often fond of saying, that reasonable notice is an individual assessment, which as a practical matter means sometimes similar cases with similar facts and similar employees, the notice period can vary, sometimes somewhat significantly, frankly. So but the reality is, I think that what we're looking at is maybe an extra month or two. And we'll talk about short service employees in a moment, but I don't think that, in my view, that all of a sudden, because there's a pandemic, that this one factor of trying to find another job is the difficulty finding new employment is going to be the dominant factor that alters the universe of wrongful dismissal cases, contrary to the hopes of the plaintiffs' bar that have been very optimistic. And I think one of the things that you have to get ready for in terms of dealing with the new world of wrongful dismissal claims is the plaintiffs' bar is getting a lot more entrepreneurial. If those of you who listen to the radio or social media, lawyers that act in the employment space for employees are becoming a lot more aggressive in recruiting clients. And to me, they're almost becoming what's quite similar to the personal injury bar, which obviously the plaintiff side personal injury bar is fairly prominent in marketing, and we're starting to see that. We're starting to even see some people that were involved in personal injury law get into employment law, as the amount of benefits that are available under the personal injury regime aren't what they used to be, quite frankly. So that's a piece. You got to recognize that it's going to be easier than ever for employees to bring these kind of claims because representatives are more aggressively soliciting that. And of course, we also have a whole group of paralegals who aren't lawyers but are licensed parties that are bringing these kind of cases quite frequently in the small claims court. We've seen more small claims cases for employees than we ever have before, and those are cases that are under $35,000 in total. So those are typically lower paid and shorter service employees. But so some of the other takeaways that are clear is I think that first of all, you need to hold workers accountable when it comes to mitigation to leverage settlement negotiations. Even if you're in a distressed industry such as the restaurant or hospitality trade, many of the skills that are present in restaurants and hospitality are transferable to other things. It's not someone's right to work in hospitality forever when there are no jobs in hospitality. So there are services that are out there that literally take an employee's skill set and provide them with, a list of jobs. I mean, why, if someone is working as a waiter, can't they work at a warehouse? They can and should, right? I mean, it should replicate much of those jobs. Certainly our approach in negotiations in these cases, and remembering when we talk about wrongful dismissal cases, the overwhelming majority of them are dealt with by means of settlement of some kind, either prior to litigation being commenced or through the mediation process. You don't need to put too much emphasis on the COVID bump. I think ultimately the position we're taking, that absent a particularly extraordinary situation, that we're not getting into saying that all of a sudden we're in a whole new realm of notice. And you can certainly say to the employee, if you think that's the case, then you're going to have to take it to trial. You're going to have to go for summary judgment and actually go to court and spend money to find out really whether your counsel's theory about where this is going is right. I mean, again, that's the approach that we really want to emphasize, that when we're dealing with wrongful dismissal litigation, that we recognize there is a possibility that damages are going to be increased, but at the end of the day, it really is going to be for this narrow window, presumably, from what we know from the Hudson's Bay cases. It has to be a termination during the pandemic, and hopefully we're coming towards the end of that now as more and more vaccines come in. So perhaps the arguments of a COVID bump is going to be confined to a relatively narrow range of terminations, and it may very well be. From some perspectives, may offer some employers the incentives to keep some of those people, at least hypothetically, on the payroll and deal with it after the pandemic is over. There's been quite a few cases recently, and certainly one of the challenges we're seeing in a lot of the claims that we're getting is we're getting a lot more claims from older employees. People are working longer than they ever have before. The days of mandatory retirement are over. The days of companies supplied defined benefit pension plans are pretty much a thing of the past, at least in the private sector in Ontario. So we're seeing a lot of older employees, and we're also people go from job to job. A lot of shorter service employees, and historically, these kind of employees didn't often sue. Like, really, if you had worked somewhere for a couple of years, like, we really are going to go through the whole bother of getting a lawyer for the sake of a month or two's pay. But the plaintiff lawyers, and certainly hence some courts, have really been pushing the margins about where damages sit in these cases, and giving some fairly short service employees 1-2 years of service damages that would be consistent with the kind of damages we typically see for employees that are, in the 5 to 6 month range, or 5 to 6 year range. So, I mean, it's becoming, and certainly we're also certainly seeing with older employees, plaintiffs taking the position that they should get a fairly enhanced notice period compared to what a shorter service younger employee would typically be awarded by a court. So let's just sort of take a look at where we are. One example of where some of these cases come from as to how high these notice periods can be. Take a look at the Samuel versus Benson Kearley case. That's the case involving an insurance salesman. It's a relatively recent decision of the Superior Court, 2020, and that was where this is sort of the two factors I was talking about: an older employee, in this case someone 61, with 3 years of service. Now, ordinarily, one would think an employee, 3 years of service, especially someone who's a salesman. So we're not talking, someone who's like a senior executive. Senior executives typically, if they haven't contracted specifically for notice, by the character of their employment, they typically get notice at the higher end of the scale, based upon the theory that it's obviously, from a logical perspective, easier to go out and get a sort of a mid-level job than it is to get an executive position. Just by the mere fact is there's way more mid-level jobs than there are very senior jobs, of course. And of course, the compensation difference between them is quite significant. But in this case, you can see, though, that the plaintiff got 6 months notice for after 3 years of service. That is a lot. That is 2 months of service for every year, and is quite comparable to what you would probably see an employee with anywhere from 4 to 7 years of service in an ordinary run-of-the-mill case, run-of-the-mill employee. Again, so I mean, that gets kind of obviously it gets kind of scary for employers when you're hiring these people that have only been there for a few years, and you're literally found yourself on the other end of the judgment owing them half a year's pay. It's a reminder, of course, why employment contracts are always a good idea. You want to take these things out of the hands of the courts, and Jeremy's going to talk to you later about where we're at with some developments on that it's important to button up your contracts. But again, you have contracts to avoid this exact kind of situation because of the level of uncertainty that's out there is significant. Another case that, again, similar facts is McGregor versus Atlantic Packaging. Certainly the favorite case of every plaintiff lawyer with a short service employee. You got a 60-year-old employee, again, with 2.5 years of service. I mean, literally gets more than 2 months per year of service and gets, again, 6 months. So these kind of cases make, quite frankly, these short service cases more difficult to settle, because certainly most employers take umbrage, and quite understandably so, at writing a check to somebody for 6 months worth of pay for someone who's been there for 2 years. It's really like that's a payment of basically representing a quarter of their tenure. It's a rather generous payment, to say the least, and probably is in and around what they'd get if they'd been there for several more years. So that does make these cases sometimes more difficult to deal with, and certainly more uncertain. However, I think that there has been some more recent cases that I have, as you see in my slide, I'm taking as a breath air. I'm almost saying, thank goodness that some common sense is coming back, and that we're not to some of these cases. And this case is the very recent decision from this year, Peninsula Employment Limited Services Limited. Again, so basically, the court does make the comment about, this is, again, the age and short service. And the court, I'm just going to read it to you because I think it's a helpful comment. I do agree that the plaintiff's age and the uncertainties in the job market at the time of termination both serve to tilt the period of reasonable notice away from the fairly short period of notice that his short period of service might otherwise indicate. However, these factors do not apply to the exclusion of the others. A balanced approach is what's called for. And that's the key, balance. Just because this person had, was going to have a difficult time finding another job, and ultimately, again, this is a sales rep, the employee got 2.5 years of service, got 3 months pay and leave notice. That, again, I know some of you out there still think that's probably too much, and it might be, frankly, for someone who's been there, but it's certainly better than 6, and certainly it's sort of a warning sign because certainly for plaintiffs that want to take on a case like this, to go to court for the Superior Court for a couple of months worth of notice, unless you're particularly well paid, is a rather it's more of a small claims court territory case in many instances. This case is George versus the Laurentian Bank Securities case. I mean, like again, when you see his title, when you say that he's an equity trading manager, that sounds like a pretty high-ranking position at a bank. You starts thinking, big time Bay Street private equity kind of guy. But the guy was making $100,000 a year, which I'm not saying isn't a lot of money. It is, but it's certainly not the amount of money that you would think a senior equity trader would be making at a bank. So, but basically, what the court basically said, look, is we're going to look at what this guy's actual job was, irrespective of the title. It's more of a salesman basically it's a title that's more impressing the people that I guess that were buying things from him, rather than he's not someone who's like, a senior manager or a private equity banker kind of thing. And the court again recognize that the employee's age will make it more difficult for him to find a job. And this, I mean, again, it seems to me that the line that pretty much whenever you're sort of past mid-50s, that sort of gets into what the courts refer to as an older as an older employee, although certainly with the way the workforce is aging, 55 in the workplace certainly isn't what it used to be. There's a lot more people working a lot longer for a variety of reasons, including sort of the decline of pensions and the like. So, I mean, moving to the next slide, and this is where, again, it's helpful. I mean, the court briefly assessed the usual factors and found that, the employee should get 2 months pay in lieu of notice. And the court came to this conclusion very importantly, even though the employee had not found a job by the time the proceedings commenced. So ultimately, this was a case where, look, this person was completely out of work, and the court just basically said, well, yes, he's got difficulty, but really, at the end of the day, what the court in the Laurentian Bank Securities case really did was give this person probably a similar level of notice to almost anyone else making $100,000 that was fired with relatively short service. So I think it's a lesson for us to see that these short service cases, that we can't let some of these sort of 6-7 month notice periods scare us. There may be some cases where it's like that. Cases where someone's likely to get 6 months, aside from just actually having some bad luck and maybe drawing around a judge, quite frankly, is basically going to be cases oftentimes involving senior people, and maybe there are individual facts that it's hard to replace that particular job. There may have been, if there had been representations about security of tenure, all those kind of things. But I think that at least at this point, some of the more recent cases are saying that these sort of long notice periods for short service employees is the exception rather than the rule, and I'm hoping that that continues to be the case. So the takeaways from this section is that you should not necessarily be providing significantly enhanced notice periods to older short service employees. I think the offers, except in cases where it's very easy to mitigate, should probably range more towards the top end of common law. Top end of like regular common law. So, I mean, when you're looking at someone who's been there for a year or two, we should be looking at, a reasonable settlement with these kind of cases is 2 or 3 months if we don't have a contract. But I think the reality is that the case law is inconsistent in this area, so the litigation is risky for both sides. And I've got to tell you, I've had several cases this year where short service employees have gone off to small claims court. Several. There's been quite a development even within the larger sort of firms that specialize in representing plaintiffs. They have sections that handle divisions down that handle these small claims cases. The limits are high enough that it's going to, encompass basically anybody who has, less than 10 years of service making, 50, 60 grand a year. You're probably crazy not to go to small claims court, because and even from the employer's perspective, you can't get a whole lot of costs from employees at small claims court, but small claims court is considerably cheaper. You usually, it's better. Oftentimes you'll have a more junior counsel there, which have a lower rate. You basically have one settlement meeting, which, unlike a private mediation, you don't pay the mediator. And then if you go to trial, you go to trial, and it's not really long and complicated. It's meant to be sort of pardon the expression, kind of the quick and dirty way of dealing with things, but it's the thing is, you don't find out until you get there. Of course, it's no more or less like the actual proceeding is still a trial proceeding like any other. So at the end of the day, it may just be that we'll see some more trials in some of these smaller cases, simply because it's so much easier to get to trial than in a superior court case where there's much more onerous discovery obligations, document exchange, and issues like that. But for short service employees who decide to bring their case in superior court, thinking that their case is worth 6 months notice and it's only worth 2, and if the employer has put a settlement offer out there that's within the regional range of common law, the consequences to the employee can be ruinous. It can basically chew up any money they get, and then they end up owing the employer a fairly hefty bill. So certainly on the plaintiff end of things, they have to be very cautious about thinking about whether to bring a case like that. So you heard me talking a little bit about employment contracts, and certainly it has been a challenging year for employment contracts and their enforceability in Ontario. Many of you have contracts where you confine your employees to the very minimums prescribed by the Employment Standards Act, and Jeremy's going to talk to you about what the courts have done to make those contracts more difficult to enforce than they had
been. Thanks, Ryan. So yeah, if you guys joined us for our quarterly webinar, which was just last month, where we talked, my partner Ryan Conlin, my partner Landon Young was on to talk about the case of Waxdale. Some of what I'm about to say is going to be a bit repetitive for you, but that is the big case that has come out. And although it was decided last year, the decision of the Supreme Court of Canada to refuse leave to appeal just happened in January. And so That is now the final word, is that what the Court of Appeal said in the Waxdale decision is now the law in Ontario and likely across the country in all common law jurisdictions as well. And so I think it's important to parse this, and I'm going to try to provide a bit of practical guidance on how to deal with and how to evaluate your own employment agreements to determine whether what you've got is an enforceable bargain. And so if you want to try to avoid the sort of mixed bag of case law that Ryan just took you through, where you're the risk to both parties, frankly, when you start a new employment relationship where you have a long-term or even it sounds like a short-term one, if some of the cases Ryan took you through also continue to be part of the jurisprudence, not having an employment agreement that's enforceable and that keeps your terminations out of the hands of these courts with their inconsistent decisions and factors that are based on the times and when the next pandemic happens or transitions or whatever. It's just a wise business strategy to have something in writing. I liken employment contracts to a prenuptial agreement. And it was sort of funny. There was for those who used to watch Oprah way back in the day, she had this show about prenups, and she was trying to tell people that if you have $1 billion, then not having a prenup is important, but half of $1 billion is still half $1 billion, right? You're still going to do okay. Whereas if you've got 100 grand in the bank, half of 100 grand, giving that away can be quite substantial. And making an agreement with someone when there's a rosy future that everyone's real happy during that honeymoon period is far easier now than it is to try to ask that person to be reasonable when the relationship ends, and often ends badly. And so in employment, having something in writing is your best way to ensure that you don't leave this in the hands of an employee who's angry, vengeful, and hoping for money, and a court that's following an inconsistent set of case law to determine what the reasonable notice period will be. And so here we are with the clause from Waxdale. This is the decision. This is the clause that actually applied to the termination of this employee. This was a without cause termination of an employee, and so the employer followed the clause in the contract. And at first glance, I read this clause, as I'm sure everyone else on this call reads it and says, well, there's nothing wrong with this. This is fine. And I agree with you. This clause is fine. This is a clause which says, in the event that your employment is terminated without cause, the use of the words without cause really is no never mind in this case, because it's just saying what will happen in that event. It doesn't say what will happen when it's otherwise, right? You shall receive 1 week notice or pay in lieu of such notice in addition to the minimum notice or pay in lieu that you'll receive. And there's no limit to how much you could receive. So you could be employed for 50 years, and now you're going to get the 8 weeks under the ESA and another 50 weeks. So clearly we're doing better than even ESA termination and severance. There may be some issues about the failure to reference this, some portion as being severance pay or not, but in general, this clause isn't at first glance at least problematic, okay? The real problem here, and this is where this employer's agreement fell down, is that somewhere else in the agreement, there was a provision that dealt with termination for just cause. And then underneath it, there was like 10 bullets that talked about the different things that would constitute just cause. And the employer's agreement said, in the event that you're guilty of any of these things, then you get no notice. We can terminate you without any notice or payment whatsoever. And it didn't say, other than as minimally required by the Employment Standards Act, it just said you get nothing. And so, unfortunately, the employer, when they prepared this, they forgot, or whoever prepared it for them forgot, that just cause is a common law concept. The words just cause do not appear in the Employment Standards Act or regulations, and the definition of what are even the grounds for disentitling an employee to the statutory entitlements of notice and severance, etc., is intentionally and very different. So there I have the definition up there for you: willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So in many ways, that's a much higher standard. Okay, whereas in common law, if someone is making a lot of mistakes, but by accident, then it's not willful. And so unless they're being willfully negligent in that sort of twisting of the words, then they can be a terrible employee, but you can never fire them without giving them their employment standards. You can not give them common law if they're guilty of just cause, but they still get their statutory entitlements. And so that is a real problem. And even though in this case, the employee was not being fired for cause, the court wrestled with the fact that the employer's agreement should be read as a whole document. And so for an employee to determine what their entitlements on termination were, they had to read all provisions that related to the termination of their employment and those entitlements. And so even though these two paragraphs were in separate places, and even though there was a severability clause, which said, sort of in this sort of standard way, if any clause of this agreement is found to be unenforceable or invalid, that the other clauses will survive and that one will go, the courts have held consistently that if you have a provision, doesn't have to be a single sentence or a single paragraph, but a provision read in a general sense, that is found invalid as a violation of a statute, you can't use a severability clause to save it. And so the employer argued, well, we have a severability clause. The termination for cause was under a separate heading than the termination without cause. These are separate parts of the agreement, and therefore you can use that. You can invoke the severability clause without offending that principle. And the court said no. Essentially, these have to be read as part of the way to determine the termination entitlements. It's one section, even if it's in separate places. And so we're not going to allow that to happen. You have violated the Employment Standards Act by having a without cause, just cause termination provision baked into your without cause. And so as a result, the whole thing is gone. And as I said, the Supreme Court of Canada has denied leave to appeal. And so what that means is this employee is entitled to common law reasonable notice with all the stuff that Ryan just discussed, as opposed to whatever the parties had intended, clearly intended and expressed in the employment contract. And it's very frustrating as an employer to come to an agreement in writing with an employee about what's going to happen, that those circumstances arise without cause termination, that there's no doubt the employee clearly understood that in the event of a without cause termination, they were going to be limited to their employment standards entitlements. It's right there, it's in black and white, and no, sorry, the agreement is gone. Because somewhere else in the agreement is some offending language, and the court is determined to read them as a sort of single section of your agreement, despite the space in the agreement and despite the clear party's intent and despite a severability clause. So what are the implications of this decision? Well, even if you have a clause, like in Waxdale, that says we're going to give you more than the Employment Standards Act entitlements on a without cause termination. So even if you're not just saying you only get ESA on termination, we're going to enhance that package for you. That clause will be void if elsewhere in the contract you have other provisions that relate to entitlements on termination, and those other provisions elsewhere are invalid or may fall, if operable, below the Employment Standards Act. And so severability language is not going to save you. Now, I have to say that our firm and many lawyers practicing on the employer side of the bar have been very careful about this for years for exactly this problem. So this case isn't making new law from the perspective of if you have a clause that falls below ESA or that offends those principles, that you're taking a risk. And so, I have to say, luckily, I'm very happy that our firm has been very careful on this point, and a number of other firms have as well. But unfortunately, I have to say also, this is a common drafting error. Large firms have made these mistakes in their template agreements. Large companies and very senior experienced HR folks have made these mistakes because you're just trying to put in your agreement something that makes sense and that the parties have agreed. And unfortunately, the courts are not reading it the way you probably intended it. And so that's creating a real issue. So what do we do here? Okay, well, let's take a pause. let's amend all of our contract templates, and let's amend all the contracts that we have employees, existing employees on. And so if February to May is usually your period for annual reviews, and I know there have been COVID and all the rest of it, but if now's the time that you would typically be having employee reviews and perhaps giving people increases in pay, giving them some kind of a signing bonus for new things, now's the time to use that as the consideration to implement agreements that are enforceable and properly drafted for existing employees, so that the intention of the agreement, which was not to violate the ESA, but to guarantee either the ESA minimums or an enhanced package, is enforceable. And you don't end up in court fighting over whether some other clause is a hidden trap in your agreement. And because of a number of other cases that have been coming down recently, it's very important not just to have that clause somewhere in the contract, but to bring it expressly to that employee's attention. And so what we've been doing actually is in all of our sign-off provisions at the end, we used to, a good contract will say, I'm signing it voluntarily, I've had the opportunity to get legal advice, I'm not under any duress or anything like that, and I understand what it is that I'm signing and its effect. That's the usual language. We've been adding to all of these provisions another one which says, and I acknowledge and agree that all the provisions of this agreement have been brought to my attention, including, without limiting the generality of the foregoing, the paragraph that deals with the termination of my employment, and we'll even cite the paragraph number. So there's no way that that employee who signs that contract can say it was buried in 5 pages. I didn't realize I was signing off and waiving my common law rights. And as a best practice, we're even including, and I understand that by agreeing to this contract and that particular termination language, I am waiving rights I may have under the common law. So there can be no doubt that this was clear and agreed by the parties. Don't refer to just cause. Just don't do it. If you're having ESA only contracts, if you're going to enhance your agreements, then you need someone who understands this to carefully draft an exemption for the ESA entitlements that they will get if they are entitled, despite being terminated for just cause. And there's language you need to use for that, and it has to be integrated, as we've seen in Waxdale, with the rest of your contract. And finally, be really careful with complicated formula and moving parts. These need to be clear and simple agreements. As I say it, just keep it simple, stupid. That's the rule, right? The KISS principle. It's permissible to have a simple clause that says you will only receive your minimum entitlements, but you will receive them and nothing further under the common law on termination of your employment. Don't reference without cause, don't reference with cause. Just say on termination, you'll get whatever it is you're supposed to get by the ESA and nothing else. That's enforceable. That's good enough. If you have nothing else in your agreement that undoes that, remove your probationary language. It's unnecessary in an ESA only contract, because if the ESA still provides for the probation that's in there, the 90 days, the 3 months you can have before someone gets notice entitlements, then that's baked into an ESA only clause. Mentioning probation just gets you into hot water potentially and can create issues down the road when legislation gets amended. So just you don't need it, take it out. Amend to exempt ESA requirements, or simply remove language that's there that talks about limiting people's entitlements to bonus, to profit sharing, to commissions, to options. There have been so many cases where employers have said, well, you have to be actively employed to be eligible for this or that, or for something to vest. The language required to make that work is very complicated. And even if you draft that perfectly, you still need to carve out the sort of boilerplate, except and then only to the extent as required by the Employment Standards Act. And if you don't do that carefully and properly and consistently, well, now you have a clause that relates to entitlements on termination that may invalidate what is otherwise an enforceable ESA agreement. So knock it off, take it out, or go to a lawyer to help you to draft this, because all you're doing is saving a few bucks and imperiling your clause, which may expose you to significant common law liability. So that's all I'll say about that. I've probably gone on a little longer than I should, but I'm going to bring you to a comment Ryan's going to take you to about a recent case that was not in the employment context, but which certainly has implications to employers' obligations in the employment context to do with good faith.
Yeah, this is a decision of the Supreme Court of Canada, and this is just one of those kind of decisions I think that sometimes just makes people hate lawyers and hate courts. As Jeremy mentioned, it's a commercial case. It's not employment. It's a case of CM Callow v. Zollinger Inc. And essentially the facts of it are fairly straightforward. It was a condominium corporation that had a service provider that was on a 2-year term that could be terminated on 10 days notice. The condo corporation had sort of led the service provider to believe that their term would be renewed. So in order to make this service provider, this condo corporation happy, the service provider provided some free services to the contractor, and then whoops, there's the 10 days notice stipulated by the contract, and it's terminated. Ultimately, the issue, this was not a case where there was any issue with the contract. It's not like Waxdale. It's basically, it was a commercial contract with a 10-day termination clause. The issue was that the court has created a new duty of honesty and good faith in performing contractual duties, and thus with over a dissent at the court, ultimately creates a new head of damages potentially for people that are operating in bad faith. Bad faith is one of those words, and there's an article about this case that my partner Landon Young wrote. It's on our website, so he goes on. We'll have more time to discuss this case than I'm going to in the next few minutes. But one of the comments that Landon makes in that article is that bad faith is a very difficult thing to define. Dishonesty is pretty easy to define, right? But bad faith, what's bad faith, and what does it mean? Where I think we're going to see implications for this in the employment context, especially, that much like with the contract in this case, it was an ongoing relationship between the parties. It's going to be around things like bonuses and what representations were made about bonuses and promotions and things along those lines. And then employees saying, well, I stayed on because, I was told I was going to get this bonus. I was, they told me I was going to, and they didn't give it to me. They promised me this promotion. They didn't give it to me. All these it's the kind of thing that historically would not be actionable. But now perhaps, especially if an employee has been terminated and these events took place within 2 years of the termination, they can throw it on as another item of damages potentially. So what does it mean for employment? The truth is, we're not going to know for the next couple of years until we actually see someone litigate some of these cases. And as I said, I think most of these, unless it's a huge dollar writing thing, I think it's going to be a head of damages as part of other types of lawsuits. But what it means is it's a reminder to employers and certainly human resources representatives, and when you're talking to people about promotions and bonuses, and recognize that your behavior is going to be, the courts are not just going to be looking at the strict terms of the contract, they're going to be looking at, did you deal honestly and in good faith with this kind of a person. I mean, you can probably tell by my tone, I'm not a fan of this case. I strongly believe, of course, that honesty and good faith is a critical element of dealing with a contract. But at the end of the day, a contract's either what's written in it, express or implied, and it opens up a whole lot of uncertainty and, frankly, more litigation on these kind of issues. So from my perspective, we're just drawing this case to your attention. It's a stay tuned kind of thing. We'll see where it plays out, remembering oftentimes that bad facts make bad law. And if there's some particularly egregious behavior on the part of an employer, it can be sanctioned under this head of damages. So those are my comments on that case. So I guess if Jeremy wants to come back, we'll see what questions we have.
Thanks, Ryan. So we have one question so far, and it's for me. But if you haven't already and you still have some burning questions, please take the time to send them in, and then we'll distribute to the presenter on the topic. So this question, I think, is an interesting one. What can an employer do if the employee is restated in a comparable position pre-leave, but they won't sign a form concerning the amended job duties? Okay, so there's a number of questions baked into this question. I think the first question is, what is the employer's obligation? And the employer's obligation is to give that person a job when they come back from their leave. And if the employee is being returned from a leave and they're being given a different job when their leave is over, and as long as that offer of an alternate position is accepted, You don't have to get anything in writing from them. If they come back and they don't express to you that this is not an acceptable thing, then if they work in that position for a while, they've condoned that what you did was, as in my view, they have condoned that you have given them an alternate position that met your obligations under the Employment Standards Act when you return someone from a leave, and that would be a defensible position to take in the event that they bring a complaint. Now, this employee deciding not to sign off, if they express when they say, I'm not signing that the reason they won't sign off is that they don't think that this is a comparable job, that they want their position back, well, then now you can't make the assumption that they're condoning the return to this alternate position as a permanent change. So there is a bit more of a risk if we're still in the IDEL period for everybody else, again, because this is a very different situation, there's a bit more of a risk that when things start returning to normal, if you're able to return other people to what was a position that was comparable or even their position or their the same kind of position, the same title and duties as they had before you brought them back, that they might say, well, you know, it's great you brought me back on a temporary basis to this other job because mine wasn't available and I took whatever work I could get because otherwise I can't get government subsidizing my unemployment. But I still expected to get my old job back when things went back to normal. And they may have a valid claim to that. So you may have to put them to a decision for someone who's refusing to sign off and say, well, we're returning you from the leave. We have this job available for you. And you need to accept that this is an alternate job. And if they won't, well, then now you have a decision to make yourself. Do you want to take the position that they're refusing the alternate position because it's not being offered on a temporary basis? Or on the other hand, do you want to let sleeping dogs lie and see how it goes? So this might be something that you'll want to talk about with your counsel to sort of figure out from a practical perspective what to do in this unique situation. All right, so the next question we have here, let me see if I can find one for Ryan. I have a whole bunch for me. Sorry, Ryan, these are all questions for me. I'll keep going, and if one comes in for you, then I'll hand it off. Do you recommend a termination clause be included in a fixed term contract? So let me start let me just say at the top of my lungs, without screaming at everybody, fixed term contracts are always bad. I hate them. They're not a good idea. If they're drafted poorly, or if there's any aspect of that contract that is equivocal or could be interpreted in more than one way, then you might end up owing the employee the balance of the contract if you need to terminate them early. There's lots of case law on that because you're not talking about common law reasonable notice. You're talking about the entitlement to a job for the duration of the fixed term agreement. And so every fixed term contract, if you have a good reason for having one, and so you insist for funding reasons or whatever other reasons, if you think it's essential that you have this fixed term contract, my advice is it absolutely must have an early termination clause, which limits people to their entitlements on termination pursuant to their service as required by the Employment Standards Act at the time that you invoke the termination, if any, and expressly not, to the balance of their fixed term. And I think there's a whole bunch of sort of follow-up questions here, but very simply, again, the ESA and even the provincial standards outside of Ontario, the entitlements there are not substantial, right? I mean, you compare that to common law, it's a fraction. So a much better thing to do, in my view, is, and it takes a little bit more, you have to sort of keep an eye on the anniversary dates of your fixed term agreements and set a calendar reminder for people in HR. But the better way, I believe, is to give people an ESA only agreement that's enforceable and well drafted, and then give them notice when you're approaching what would have been the end of a fixed term, and just tell them your employment is ending on whatever that date is, and then give them their employment standards entitlements. It's a much better way to go. You don't have to risk the exposure to the balance of a contract or ending up in common law if you accidentally forget to renew or extend a fixed term and they work an hour after the term of that agreement. Now you have a common law employee employed indefinitely, and they're going to get common law notice of the termination of their employment after that. So it just introduces a whole bunch of risk. I hate it. If you want us to draft one for you, I've done them many, many times, but you need to do this really carefully. You always need an early termination clause, and you need to be especially careful with the employment standards entitlements that the employee gets. So if you have an employee who you are recalling to their same job and they don't want to take it, well, then that is a refusal of the recall. You then give them a letter which says, if you refuse this, you have to warn them, if you refuse this, then we will deem you to have resigned your employment. Are you sure that you're not going to accept this job? And then they will have to respond to you. And if they don't respond to you, then you take the position that they have resigned if they don't return to work. And then you have complied with your obligations under the Employment Standards Act. If it's a different job and you can show that the work is available, it's comparable, hopefully the compensation is the same, and they are refusing to return, document that, advise them that by refusing this suitable alternate employment, which is what your obligation is as an employer to provide, that they are resigning, they will be deemed to be resigning their employment, and ask them again. We'll give you a week to think about this, but if you don't accept this position in return, we'll deem you to have resigned your employment, and we'll give you an ROE that says resigned. And most employees, when they see that, will grumble. They may call the Employment Standards Act, the Employment Standards branch, or their lawyer. But I think ultimately that's the correct answer, as long as, and this is critical, in good faith, following your obligations under the ESA, you really don't have their position to give them. And the position you are offering truly is a suitable alternate job that meets your obligations. And if those two boxes can't be checked off, then I would be very careful about taking that hardline position that they've resigned. I think it's very likely that if you can't find a practical way around this difference between the parties, you're going to see an employment standards complaint, and you're going to have to prove yourself innocent. So as much as you may be able to justify those decisions, I think you may have to be prepared to justify to an employment standards officer that what you've done is the lawful way to conduct yourself in this circumstance. So, I know we went a little bit long. One of the things that there's one more question here about offering working notice rather than a package. You can always offer that to someone in a settlement, but obviously employment standards severance pay can never be paid out in that way through working notice. It always has to be a lump sum package in all cases, whether that's in your employment contract or whether it's in a severance agreement with an employee in exchange for a release. That's very important. You cannot give them less than what their employment standards entitlements are. So, it looks like those are all the questions we'll have time for today. We always like to start and stop on time, so sorry to those we couldn't get to. Thanks again. Ryan, sorry we didn't have any burning questions for you today, but I did enjoy your presentations. So thanks again, everybody. I'm glad you joined us. Stay safe, take care, and do feel free to get in touch with us if you have any burning questions that we can help directly for. Okay, thanks very much. Have a great day, everybody.